Today, we're diving into a really big shift that's happening across the European Union. There's a whole new set of rules, changing the game for businesses, and we're going to break down how you can turn what looks like a super complex challenge into a serious competitive advantage.
So, let's start with a bit of a riddle. What on earth could possibly connect artificial intelligence, the coffee beans in your supply chain, and, say, the sleek design of your app? I mean, they seem totally unrelated, right?
Well, the one thing that connects them all is this massive new wave of EU rules. And this isn't just a few minor updates here and there. No, we're talking about a fundamental rewriting of the rulebook that touches everything, from your core tech all the way to how you talk to your customers. Now, when you're faced with all of this, it can feel like you're trying to find your way through a really dense legal maze. But what if we could look at it differently? What if we could see it not as a maze, but as a strategic map?
And let's be real, for all the innovators and entrepreneurs out there, the first reaction to a flood of new regulations is usually just feeling completely overwhelmed. It can feel like this huge burden that's just designed to slow you down.
But here's the big idea for our whole explainer today. What if it's not a burden at all? What if this new rulebook is actually a blueprint, a kind of step-by-step guide to building a business that's more resilient, more trustworthy, and in the end, a lot more valuable? To make sense of all this, we're going to use a really simple framework, the IP and compliance stack. Just think of it as 3 layers. At the very bottom, you have your core. That's your secret sauce, your foundational tech. In the middle, you've got the product itself, its design, its data. And then right at the top is the market. That's how you communicate and build trust. So let's build this thing from the ground up.
Okay, let's start at the foundation with layer 1, guarding your core. This is all about protecting the stuff that truly makes your business unique.
And the first tool in our toolbox here is the EU's Trade Secret Directive. It has a surprisingly simple 3-part test. For something to count as a trade secret, it has to actually be secret. Its value has to come from being a secret, and, this is key, you have to take reasonable steps to keep it a secret. You gotta have all 3.
You know, this quote from Maria Boicova-Wynants just nails it. If your special process can be copied right off a poster or a slide in your pitch deck, it's not really a competitive edge, is it? It's more like a free tutorial for your competition. So actively protecting it isn't just a suggestion, it's a requirement.
Let's make this a little more real. For a cutting-edge food tech company, their core might be the breakthrough process they developed for creating cultivated meat. You know, that unique bioreactor process or special cell culture medium. That's their trade secret. That's their fundamental advantage.
But just protecting the process isn't the whole story. When that process creates something truly new, like cultivated meat, it falls under the Novel Food Regulation. And what that means is, before you can sell a single bite, that product has to pass a super rigorous safety assessment by the European Food Safety Authority, also known as EFSA. Think of it as a critical gate you have to pass through for deep tech food innovation.
Okay, so our core is protected. Now we can build the next layer of our stack. Owning your product. This is all about securing the rights to the actual thing, whether it's physical or digital, that you're selling to people.
And a huge change here is the EU design law reform. The old rules, well, they were built for an analog world, really focused on how physical things looked. The new rules, though, are built for today. They've expanded protection to cover things like digital designs, the smooth animations in your app, your graphical user interface, and even the layout of a retail store.
And to make all these protections super clear, the new law gives us a simple but really powerful tool. You know how we have the C symbol for copyright? Well, now there's an official symbol for a registered EU design. It's the letter D inside a circle. This lets you tell the whole world instantly that your design is protected.
But there's another layer to the product now. It's data. The new Eco-Design for Sustainable Products regulation is going to require something called digital product passports for a lot of goods. This is all about making products more durable, more repairable, more sustainable. It basically means data about a product's life cycle becomes a core part of the product itself, turning transparency into a real, tangible asset. And that brings us to the final, top layer of our stack, winning market trust. Once your core and your product are secure, this layer is all about how your business shows up in the world, how you build trust through responsible sourcing and communication. A huge piece of this is the world's first major law on artificial intelligence, the AI Act. It takes a risk-based approach, and some practices are just deemed an unacceptable risk. These are just flat-out banned. We're talking about things like manipulative AI, social scoring systems, and scraping facial images from the internet without a target. This is all about building a foundation of trust in how AI gets used. And don't think this is some far-off problem for the future. The rollout is already happening. The first bans on those unacceptable risk AIs, they kick in at the start of 2025. Then, by August of that year, the rules for general-purpose AI models, the kind that powers so many tools today, start to apply. The clock is definitely ticking on this one.
Trust also goes deep into your supply chain, and the EU deforestation regulation is a perfect example. The goal here is pretty simple. Make sure products sold in the EU aren't fueling deforestation. And it covers a huge range of things we use every day: coffee, cocoa, rubber, timber, and even the products made from them, like chocolate and furniture.
Now, under this regulation, what you have to do depends on where you are in the supply chain. If you're an operator, meaning you're the first one to bring the product into the EU market, then you're on the hook for full due diligence. But if you're a trader, say a retailer, your responsibilities change based on your size. The big guys have the same duties as operators, while smaller businesses have a slightly easier path. The main thing is you have to know exactly where you fit.
And finally, market trust really just comes down to telling the truth in your marketing. The Nutrition and Health Claims Regulation is crystal clear on this. Any claim you make, whether it's something simple like low fat or something more complicated, has to be accurate and backed by solid scientific proof. You can't just make stuff up.
So let's put it all together. Building out your compliance stack isn't about just ticking boxes on some boring checklist. It's about creating a single, integrated asset that protects and strengthens your entire business from the inside out.
And here it is, your completed stack. Your core is guarded by trade secret and novel food rules. Your product is owned through modern design rights and made more valuable with digital product passports. And your presence in the market is built on a foundation of trust, thanks to compliance with the AI Act, the EUDR, and rules on truthful marketing. See how each layer supports the next? It creates this solid, really valuable foundation.
Which leaves us with one final big thought to chew on. In this new world, where trust and transparency are literally being written into law, maybe mastering compliance isn't just a legal chore. Maybe it's the ultimate form of innovation.